Well, welcome to the show. Today is Judge Raquel West. And let me share my screen and let's get this party started. So share screen.
24 DCCR 0122, State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum as well.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I have received the sentencing memorandum memorandum at 5:47 PM yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well?
Same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to council. Did you both receive those as well?
Yes, Judge.
I didn't.
Okay, is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right, Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. We have a person present from the Dream Center. If the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
it's an option that doesn't cost the court anything, or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No, Your Honor.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking the court for. I have sort of personally taken Catherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for. She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When, I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well, to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, She felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that. Or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Gertz. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that are on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she can continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information that you have before you.
All right, thank you. Anything else?
Would you like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That, after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that. And when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility, in Oxford House in Spring, and I worked there. And so I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right out of here. And I'm sorry, I'm very nervous today. And I know that my past record is, like Brian said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some good, really good choices with my Mid-County AA friends. They've helped me a lot, and I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you.
Thank you.
So, Ms. Welch, Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and given chances and things like that, but it also is about making our community safe. And I have to look back, this is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to safety 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI. That your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 years, back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one, so they give you 15 years, and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find, and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand, to some extent, addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so, good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned. Mr. Mendoza, turn around. Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, 3rd or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor.
Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing him $600 a month. And he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and then he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GED program, all those things. required money, and that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated and he wanted to take his boot off to show the director the problem that he had. And that's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants opportunity to go back to he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say of what happened with that, but I'm sure there's an explanation, and I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that Safe P he completed and then was placed on zero tolerance in the high medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse Safe P.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse Safe P, and he absconded. And he never went to relapse.
So he wasn't in custody?
No.
Okay. And then, so we didn't see him again until August 11th of 2023, when he was arrested in Houston. So here's the thing. Whether you probably didn't get any paperwork, come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. Gave you upfront time, continued you on probation. Courtesy supervision was sent to Harris County. And then we have the scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse Safe P, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously I agree with the probation department's recommendation for revocation. I think he's had more than enough chances, Judge. In fact, there's just one thing I want to make the court aware of. If I can call Ms. Martinez real quick.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were the supervising, Ms. Mendoza was on Harris County supervision, correct?
Yes, sir.
And you were the Jefferson County officer responsible for monitoring, is that correct?
Yes.
And back in October, when he started having these violations and the warrant was issued, did you advise him to turn himself in?
Yes.
And what was his response to you?
He had responded with an email that said, "Ha."
That was his only reply to you? Did I ask you to print me out a copy of that?
Yes.
Showing you what I marked as Exhibit 1 for purposes of this hearing. Is this a copy of the email with his reply to you?
Yes.
to the defense attorney, Your Honor. To the court, for purposes of this hearing, I offer State's Exhibit 1.
It's admitted.
And is that pretty consistent with his level of cooperation and attempts to provide probation while he's been supervised?
Yes, sir.
No other questions, Your Honor.
All right, any questions?
Just a couple. I want to clarify on the relapse program. You said y'all came to court on motion to revoke. Is that my understanding?
Yes,
And so the safety relapse was ordered by Judge West,
yes,
and he was here. The defendant was here. Mr. Mendoza was here that time.
yes, sir.
Well, wouldn't he have been taken into custody?
Let me make sure, because I wasn't supervising.
Okay.
It may have been through an administrative hearing.
I'm trying to look.
Let's-
The worst freaking state to live in right now is Alabama, and nobody's talking about it. I spent 30 years in the insurance industry. What I'm about to tell you will explain why Alabama pays more for car insurance than any other state in the country, and how you could fix it and save up to 80% on your rate. Let me make this simple. If you're paying over $75 a month, you're being overcharged. Drivers in Alabama are being charged almost 2 times more for the same coverage compared to the rest of the country. Because you pay the most, the industry sees Alabama as one giant cash cow, and most people have no clue why. You have the lowest claim frequency, are the safest drivers in the country, and still pay the highest rates. And here's the part no one talks about. Most people don't realize there's a new way to force them to recalculate your rate because no one told you yet. My best friend Alan lives in Huntsville, perfect record, had been paying $170 a month for 15 years. I told him to try my website. He found the same coverage for $68. That's a 60% reduction just by going through my website instead of theirs. But they won't call you with a better rate. Why would they? They don't want to lower your rate if they don't have to. You need to be proactive. Go through my service and get what you deserve. When you click below, you'll reach my website where you just fill out an application. Takes about 5 minutes. It will ask for your zip code, about your vehicle, and some other information. Then it will show you what you qualify for. That's why Alabama drivers using the site are claiming rates as low as $39 a month. After 3 decades in this industry, here's the truth you need to hear. If you're a homeowner, have multiple vehicles, and/or are already insured, the amount you will save will be even more. If you have any combination of those, we used to call you triple advantage clients who are highly sought after by the industry. My father-in-law in Birmingham was paying $250 a month for 2 cars, and he applied through the site and dropped to $50 a month. No downgrade in coverage, just taking advantage of his situation. Listen closely. Right now, you actually hold the leverage. The beginning of the year means one thing, industry quotas. And they need new policies on the books, fast. When you check your rate through my official website, carriers are forced to recalculate your rate without penalizing you for the state you live in. Right now is the best time to act, and once quotas are filled, this pricing window can tighten back up. I've seen this cycle for decades. Most people never check rate and stay stuck paying more. We call them sleepers, not bad drivers, just unaware drivers. Don't be one. The site is free to use, and it takes about 5 minutes to answer basic questions and check what you qualify for. If you're an Alabama driver with 0 DUIs, potential savings up to 80% are on the table during this period. But quota seasons don't last forever. Once targets are hit, incentives really shrink. 5 minutes today could save you hundreds or even thousands this year. Tap below, enter your zip code to verify you live in the state of Alabama, then complete the quick application. If you are family, this is exactly what I'd tell you. Check your rate now while the window is open.
I shouldn't even be talking about this, but Powerball and Mega Millions are trying to put me in jail after I discovered how any American can hit at least 4 numbers every week. I used to be a truck driver. I lived on the road, spent days away from home, and could barely watch my kids grow up. I played every week. I would pick random numbers and pray that God would let me win at least once, just like most people do. I never won a single cent. One day, I got so frustrated I almost tore up all my tickets, until I saw a video that changed everything. Most people still don't know this, but in 2025, no one needs to rely on luck or those tricks to win several times in a row anymore. Sounds crazy, I know, but give me 15 seconds to explain. After analyzing the biggest lottery winners in history, Dr. Leonard Voss, a former NASA developer, discovered a simple loophole they've been trying to keep hidden for years. A loophole so powerful, when you use it, the chances of not hitting at least 4 numbers are basically 0. You only need 3 clicks to predict the numbers. Any lazy American who uses it can hit 4, 5, or even 6 numbers every week. I'll leave the step-by-step video from Dr. Voss right here on the button, and if you're smart, you'll watch it and secure your retirement today. I admit I was skeptical at first, but
It looks like the hearing was completed over the phone. Okay, wait, he wasn't on here, it was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest. So he wasn't made aware at that time that he was going to have a warrant and they were requesting relapse safety.
I have no further questions of her, Judge.
Right, anything
I have
else?
no other questions for Ms.
Your Honor.
Martinez.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because we
Sure.
talked with her.
Go ahead.
Would you like to tell the court? Do you want to tell the court?
Y'all saying I went to safety twice, I never went.
Nobody's saying you went to SafeP twice. We're saying you went to
You're saying
SafeP.
I'm
Hold on,
absconding?
don't, listen. I'm gonna let you talk, but don't talk over me. We're saying that you went to SafeP and then that you were ordered to go to the SafeP relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to SafeP relapse. Go ahead.
She said I was supposed to turn myself in. That was after I did the 9 months where felony assault got dropped to a misdemeanor terrorist threat.
Mm-hmm.
So when I was here, y'all let me out. And then I was trying to work and they kept saying that I was messing with the scam device.
Okay.
So I was actually at work and she sent me a message to my phone. And I was trying to work and trying to pay, for the devices and stuff, since they were violating me for operating my truck without court permission.
Mm-hmm.
So that's when I just didn't turn myself in.
Right. So did you respond? Is that email? That was
Yes, ma'am.
that's what you thought about all that?
Yes, ma'am, I did actually say that.
You thought that was funny?
It's because I was agitated and I was taking lunch at work, and I was trying to do things, trying to make money to take the classes, but with being on the scam device.
Well, you had money to buy alcohol. You hadn't, because you kept drinking, because you kept messing, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long. But the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. I mean, seriously, you got the initial probation in 2021.
Trading isn't about being early, it's about being
You got you got SafeP, you got some upfront time because of the Harris County issue, didn't revoke you, haven't revoked you, 3 times haven't revoked you, and here we are with all of these violations.
Through your TDCJ program, I was doing what I needed. The only time I had issues when I had the foot problem that I got from the halfway house. That's the only reason they said I absconded from the TDCJ program.
Okay.
I've actually done well through the program, through with the supervisor division. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean, how old are you? How old are you?
I'm 43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to SafeP, you got aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can
We're done. At this, we're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy, and then when you're done with that, you can go back with the bailiff. There you go. Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
Mm-hmm. That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking. I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as he was, if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something that being the court's.
Sure.
Oh. You weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working, that he was asking the court to, I know, he knows it's a big ask, but.
Well, I mean, I don't know, it kind of is, and typically I let people who are working do it on weekends. This is just how the weekends,
I have no
for his
issue
weekends.
with the erratic nature.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand? So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, Judge, it
the
wasn't.
bond, it wasn't a condition? Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry?
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, don't have.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the 9th. So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay? And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave, so it could be 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
We're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay, if it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay, so that second one in October, you're gonna go, we're gonna get this done. Because that's your long days off, so we're gonna get that week all done. So you're gonna go in on the 16th, you're gonna get out on the 23rd. So that gives you one overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
We're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December, so you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay, all right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it? $500 fine is obviously part of that as well. Yes.
Thank you, Your Honor.
Emily, thank you, Mr. Nichols. Emily, Mary Lockard Fury, cause numbers 24 DCCR 1374, 1905, 1906, and 1907.
And Judge, I brought something, Judge, this has been the one with federal
Yes.
issues.
Mhm.
And we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts, and she has charges also pending in Chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, informed me that he thinks it's going to happen either, he alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct, so I don't have control over it, because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that you know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where I have to clean the state charges and the federal charges are coming. That's why I brought that email.
I appreciate the email. If you don't mind, I'm going to hang on to this.
Absolutely.
I might give Ray a quick email or a call just to find, I've known him we used to work together, so I'm fine with.
I've spoken with him, I've sent him all of the restitution amounts for other cases.
Yeah, and he may be waiting on other.
We had like a 6-hour proper meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and anything. It's really just waiting for, he's claiming a debriefing and the charge is coming, but it's taking
Okay.
quite some time.
I'm going to do, let's do 45 days. reset, and then I'll email him or give him a call and just see if he can, if maybe that helps, or at least I can find out if it's, that they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
In the first email that's on there, you might notice I was getting heat from Jefferson County, parentheses, Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between
If
now
I
and
know
then.
anything, I'll call him for it.
Okay, thank you. All right, you're free to go. 45 days. Thank you, Mr. Rennick. Did we see Mr. Wilkerson, Mr. Cole, Mr. Adams? See, Mr. Cole, you have Leonard Idlebird.
Yes, sir.
Oh, that's okay. I think it might help just to others to know what's going on too. Would you put a sticky on that and then put it on my desk just to remind me to do something with it, please, ma'am? Good morning, Mr. Cole.
Morning, y'all.
Good. Good morning, sir. Are you Leonard Idlebird?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. I e-filed the,
but I don't see that it's been done yet.
it's been done.
It has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report?
Yes, Your
They
Honor.
sent it to you?
Yes, Your Honor.
Oh.
To me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it, but
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. Obviously, we need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to Ms. Malfino and
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here in
Yes,
court.
yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay, all right, we'll see you in a couple of weeks. Mr. Gertz, you've got David Hatcher. Morning.
Judge, how are you?
Good. How about you?
Well, I'm good. Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so excited.
I can see it all over your face.
Yeah. Good morning, you're David Hatcher. And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor.
Oh,
And it's pretty non-specific. Any offer that was going to be made is going to be a pen time offer.
okay. Let me get that.
We were
pulled up.
looking for something vastly different than that, so.
All right,
we're
so
on the same page.
you're David Hatcher. And Mr. Hatcher, you're charged with a third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, anything that you guys are waiting on discovery-wise?
Nothing I know of. Discovery.
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're free to go. And Christopher Thomas, Mr. Gertz.
Judge, we'll meet Ashley back for that.
Did she step out? Did Ash, which way did she go?
This is important, so.
Just have a seat for a second. I'll recall it in just a second.
Thanks, Judge. Sorry.
Mr. Kelly, you've got Donald Owens.
He's present.
Good morning, you're Donald Owens? And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
Stay true.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you.
Thank you. See, Mr. Lewis, you have Naquindon,
He's right here.
oh, there you are. Naquindon Acleese.
Yes, Judge.
Good morning, you're Naquindon Acleese.
Judge, you're gonna ask me this in sentence, I'll go ahead and explain now. The reason it's now a probation offer, instead of the 10-time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery, starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court, he's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. I need your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquindon Acleese,
Yes, ma'am.
and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Acleese, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Acleese is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that. You shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay? We'll see you back.
Thank you, Your Honor.
Good morning. Are you Karis Antoine? Yes, ma'am. And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay.
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
Okay.
Yes, because I talked to him Friday and.
Okay, that's good. I just wanted to make sure. You're good. Okay. And he'll waive the formal reading of the indictment?
he does, Judge.
Mr. Antoine, in cause number 24 DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge? You either did it or you didn't do it. Guilty or not guilty? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Antoine is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing. So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that, Judge. He has no felony history that I see.
right? Let me look at this affidavit real quick.
The charge itself is for hitting a child with a belt, over discipline, essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went. When
Okay.
I do see him, I see him with my mom.
Supervision.
Her mom.
Okay.
And I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up, once you're on probation, hopefully to doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means, though, that he still has to go, right? Okay, so you're still going to have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay, makes sense? It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're going to do all the right things between now and sentencing, okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing. Once you're released from jail, you're going to get some paperwork today. It's going to have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning. If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, I would say at this point, it needs to be all of your children, and then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Yes, ma'am.
But it is.
I really have something important to tell you.
What?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to stop for my kids.
Well,
he's a baby. He's been with me since 12. Like,
who, where's the mom?
we don't talk. Since the case going on, we don't talk like that. Like my mom and her mom, that's when we meet up. But
I think the court's question is the mother of the 10-month-old is the mother of the child in this case?
Yes.
So where's the child that was in this case live?
She's with her mom. I don't see them like that. Like, we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both of your children?
Yes, ma'am.
But the baby lives with you, and the other child lives with her?
Yes. She got 4 other kids who live with her. I just got one.
Did you go through anything with CPS as far as they were, I mean, we have an order for some CPS records, but was there anything to CPS get involved?
No, ma'am, I never went through nothing like that.
Okay.
I don't think anything's been provided to us in response to that order.
It doesn't look like it. So maybe that's because there wasn't anything.
I think it was important that I tell you that I have.
No. I would much rather you be honest, but, and if you're raising, let me look at something real quick.
No, not at all.
Yes, Judge, and just to clarify, the child is, in this case, not his biological child.
Okay. So how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
one with that. Where you, and then the other 2, or where are they?
They are with her, and all my other 2, they're with their moms.
With their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but that this isn't your own biological child that's the subject of this case.
Right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, Judge.
Thank you. It's no contact without supervision except for the 10-month-old. Mr. Lewis, you have a sentencing with Shay Brooks.
Yes, ma'am.
Sentencing. Good morning. Are you Shay Brooks?
Good morning, Shy.
Shy. And Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Good. State has, Judge.
Any additions or corrections?
No, from the state.
Not from the state, but we just asked the court followed the reading of the party.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. Yes. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Yes. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Thank you.
These transforming glasses automatically adjust to what you're
Good morning, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder, Mr. Rojas told me this morning that you have the intention of trying to hire an attorney?
Yes, ma'am.
Okay, so I need you, if your family or you is going to do that, I need that done within the next 30 days.
Yes,
I'm gonna reset your case one time. Obviously, I can't have you just sitting in jail while we're not doing anything on your case. And so Mr. Rojas will remain your attorney until or unless you hire someone. If for some reason it doesn't work out that you hire someone before that next court date, then we're going to move forward with Mr. Rojas, okay? Okay, you can go back with the bailiff. Thank you. Ms. Pratt? Ms. Pratt, come up, please. Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I had the patch, because I found out that I have a tumor in my kidney.
Okay.
While I was in jail, so that's why I can't urinate.
Okay. Because I have notification.
The lady came from Vienna to put the patch on. It was real late at night in jail.
So I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what I don't have, that's not true. So I'm going to
I
find.
had the paper at home. I didn't bring it with me.
Well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
You change it.
Yeah.
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
You being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right.
Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your chair.
I've been up all night crying.
Okay, I'm going to raise your bond this time for violating your your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff. Good morning, sir. Are you Robert Hebert?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hebert, in cause number 25 DCCR 0740, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from February 11th of 2025. And how do you plead to that charge?
Okay.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Because you did what they charged you with.
Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
The paperwork on the tablet, did y'all go over it? And do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
That's correct.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hebert is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. See, Brandon Henderson.
I don't know. They'll tell you. They'll figure.
Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
Will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Mills, in cause number 25 DCCR 0082, you're charged with a second-degree felony offense of assault on a peace officer from November 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
I understand.
All right, you got to stop buying generic Viagra if y'all over 40. You can get 9 pills of 100 milligram generic.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am, I understand.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Mills is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices
ma'am.
qualify. I have to read the whole thing to you.
Oh, yes, ma'am.
That's okay, that's okay. And see, now I'm gonna mess it up because I got, no, you're fine. You should, just, that's okay, just read it to make sure you understand what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Just for the record, Judge, I believe Mr. Nichols has agreed to dismiss his misdemeanor case in County Court 2.
We have.
Okay.
Okay, then I'm sure Mr. Nichols will take care of that, and they'll, that way you'll be able to not have that holding you out there anymore, okay?
Okay, that's good.
On that,
All right.
on that judge
Good luck to you,
case.
sir. You can go back with the
Thank you very
bailiff.
much.
Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp, in cause number 25 DCCR 0916, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025. The indictment alleges you were previously convicted of theft, a third-degree felony, January 20th of 1987. Also on that same date, aggravated robbery, a first-degree felony. And after those were final, you were convicted of possession of a controlled substance, a second-degree felony, October 9th of 1998. What that means is that if you go to trial in this case and you're found guilty and those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0917, you're also charged with a second-degree felony offense of aggravated assault with a deadly weapon. Those same prior offenses are listed in that indictment as well, again, making this for punishment purposes, if convicted, a habitual offender status, which means minimum 25 up to 99 years or life in prison. Do you understand? In each of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter pleas of guilty in your cases, to proceed on, I guess that would be count one only.
Yes, Your Honor.
So just the offense, not the underlying prior offenses. So go on count one only for a 15-year term in the institutional division of the Texas Department of Corrections. You've got every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter pleas. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Sharp, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Sharp, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. So talk to that attorney and they'll file the appropriate paperwork, and then as soon as they do that, I will set it for a hearing on a bond, okay? Good morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance.
Imagine being able to build an app with your name on it.
Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again, for punishment purposes. That would make this a second-degree felony offense, if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file with the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so. Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay? All right. Yes, good morning. You're Norberto Armenta?
Yes, ma'am.
Then will your client waive the formal reading of the indictment?
So, he will, Your Honor.
Let me,
And Judge, if we may proceed on what I have numbered as 1, 2, and 3. My position on that is it's the first paragraph, the second paragraph, which is a jurisdictional paragraph to get us to the DWI third, and then a regular felony prior.
Okay, so technically two.
Technically two. I
Two
just
counts with
didn't know
the
if-
second paragraph.
how it kind of looks like a paragraph on its own, but it's just jurisdiction.
Okay, and so in cause number 25, DCCR 0168, you're charged with the third-degree felony offense of driving while intoxicated, third or more. That's from April 25th of 2024. The indictment alleges you were previously convicted of driving while intoxicated February 5th of 1998 in Harris County, Texas, February 6th of 2008 in Harris County, Texas, and then again September 8th of 2023 in Harris County, Texas. And then the second count in this indictment alleges that you were previously convicted of possession of a controlled substance, second-degree felony, June 24th of 2004. And how do you plead to that charge?
Guilty.
And are all those prior convictions that I read out for DWI as well as the possession of a controlled substance true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 12 years in prison. And I want to make sure you understand what that means is you're leaving your punishment up to me. And as long as I don't give you more than 12 years in prison, then you can't appeal. If I can give you 12, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that, and is that what you want to do?
Yes, ma'am.
It shows also as part of this agreement that the state will dismiss cause number 25, DCCR 0169, and it will run concurrently with any other felonies that you are currently serving time on. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Armenta is not competent?
No, I'm aware of that.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing, right? You can go back with the bailiff.
Your Honor, just to be clear on the paperwork, it reflects we're not requesting probation, we're requesting a five years.
I saw that, yes, sir, thank you. All right, you can go back with the bailiff.
I'll be out to see.
Good morning, are you Jarrett Matthews?
Yes, ma'am.
In cause number 23, DCCR 1211, Mr. Matthews is charged with unlawful possession of a firearm by a felon. Mr. Kimler has filed a motion asking that I reduce bond, which is currently set at, is it 100,000?
Yes, ma'am.
Let me look at something real quick.
This crash ship.
Mr. Kimler, you may proceed. Do you, are you going to call your client?
Yes, Your Honor.
Mr. Matthews, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead, Mr. Kimler.
Mr. Matthews, where do you live? Where do you reside?
Lake Charles, Louisiana.
And how long have you lived here?
Since I was born.
And you were passing through on Interstate 10 when you got this case, is that correct?
Yes, sir.
Why is your bond at $100,000? What's your understanding of all this? Put that amount?
I missed court. I had bonded out, my bond was $30,000. And I bonded out, but I had a old case in Louisiana.
Calcasieu Parish?
Yes, sir. No, Jeff Davis Parish.
Jefferson Davis Parish, all right.
And I took time on that case.
So you received a sentence in Jefferson Davis Parish?
Yes, sir.
And how long was that sentence and when did you receive it?
It was a 4-year sentence and I turned myself in March 18th of 2024.
All right, and then how long were you in the Louisiana Department of Corrections incarcerated?
Till about 3 weeks ago.
Okay. And so did you discharge your Louisiana sentence?
Yes, sir. I was extradited here.
And you were extradited here from Louisiana?
Yes, sir.
So if you missed a court date here, was that, to your understanding, that was a time when you were incarcerated in Louisiana?
Yes, sir. I notified my lawyer and the bondsman the day I turned myself in. Well, I notified my lawyer.
Who was your lawyer over here?
Charles Rojas.
And you let Mr. Rojas know that you were going into custody in Louisiana?
And it doesn't look like it was a bond forfeiture. I think it was an at-large without proper bond because he was
out of state
in custody, is what it looks like to me.
In any case, Your Honor, wasn't in court, wasn't voluntary, so we would ask the court to reinstate the original bond.
Ms. Molfino?
Judge, my position is that his criminal history in Louisiana, which sometimes is difficult to tell exactly what it is from where, but it's not a single incident, it's multiple incidents involving guns and drugs, or also a suggestion of drugs in this car where the gun was located, and he was also evading officers. So just based on the fact that he does have history in Louisiana and will probably return to Louisiana if out on bond, I would just ask the court to consider that bond sufficient.
I don't know if there's a risk assessment from DPS. Do we have the form that you get from DPS on bonds?
No, I don't have that. The magistrates at the jail get that. I can get it if you want me to.
I might take a look at it maybe before. I know the states, I know I'm not disparaging Ms. Muffin.
Hold on, what?
I know they get it next door. He pulls them up to look at it. That might be a better reference as far as his assessment. I think it's called a risk. No, there's a thing now that they're supposed to look at. It's DPS compiles it like a risk assessment.
There's none in here. For some reason, that's not scanned into this case. And so what I can do, not sure why not, it should be if back when that bond was set, it looks like there was a bond set.
I think 30,000 was the original bond.
Right, and that was back in 2022, probably on the date of the arrest. Yeah, when he was arrested. And at that time, there may or may not have been the, that's a fairly new program, so that was not something that was in existence in 2022 when this bond was set, so they took into consideration whatever they had under the available history at the time in Jefferson County primarily. There were some things they could look at, but not the new warrant. If everybody would just give me a second, I am going to take judicial notice of the court's file, including the probable cause affidavit. Give me a second to read that, please.
And Your Honor, we could just reset if the court wants to take under advisement to get the report.
Let me just read this first.
Did you ever compete at Old Girls Back Time? Okay.
Today. Yeah, I think it's probably important that I look at this. Honestly, Mr. Kimler, I'm not sure that it's going to be a positive or a negative. I'm not real sure based on what I'm reading and what potential criminal history there is that the $100,000 bond is sufficient, honestly.
Okay.
So, I
Well,
mean,
it's not my intent to get the court to raise it.
well, if you want me to look at everything, I will take a look at it. And so I'm going to reset it 1 week. I'll get them to do that. I would like to, what was the case that you just got out of prison for over in Louisiana?
Attempted possession of a firearm by a felon.
Okay. So, obviously a previous felon, if we're gonna have a felon in possession of a firearm, and this is, okay. All right, so we'll reset it for 1 week. And if you can get with Mr. Ruin, I think is.
Turns out if you've been in a car accident,
Now here's where it gets heavy. Michael Collison agrees to plead no contest to larceny and Matthews with the more serious possession charge dropped.
I think
Sounds like a win? Maybe. But look closer that no contest plea still carries the same sentencing weight as a guilty one.
Maybe at a bail bond
He
board
avoids
meeting
trial, but the
where
consequences remain
we
real.
can address
It's a legal chess
if
move,
and
and it
how
hints at the
those
DA's
conditions
willingness to
can be
make deals
relayed
when
when we
treatment
do
and
them
accountability
here in
might serve
court
better
to
than
you
more
guys.
jail
But
time.
that's the thing is
Would you
that's
take that
every
plea if you were in his
court
shoes?
does it differently.
What happens when
But
bond conditions
the
change
court
mid-case
date and the
and no one
bond
tells the bondsman?
forfeiture,
Welcome to a
it is
courtroom
what it
battle where
is. I mean,
communication
if
breakdown
they
meets legal
didn't show up,
consequence.
you're not
Today,
saying you
Judge
didn't
takes
know
on not
about the
one,
court
but two
date.
cases
And
involving
so
bond
I think
forfeitures that have
regardless
left
of
bail
why I
bondsmen
said
furious,
something,
frustrated,
whether
and
it was
feeling
because of
blindsided.
a bond
In
issue,
both
that,
cases,
to
the
me, that's
defendants
two,
were
we're
hit
talking
with
about two separate
conditions like
things.
drug patches
Somebody
and
didn't show up
GPS
for
monitoring,
court because
but
of
the
violation
problem,
of a bond
these weren't
condition,
part of the original
but
bond
they didn't show up
agreements,
for
and the
court.
bonding
So
company
that's a
says they were never
forfeiture.
told.
If
Tensions
I
rise fast
know,
as the court pushes back, asking,
it's just
isn't it your
different on
job
how,
to
it
keep up with the
depends
court's evolving
on, for me,
conditions?
how I handle
We'll hear
them,
from
and we can
judge,
talk about
defense
that
attorneys,
later.
bondsmen, and the DA, all clashing over who's really responsible when defendants violate court-ordered terms after bond has already been posted. This isn't just about missed appointments. It's about systemic flaws, legal gray areas, and whether the courts are setting up bonding companies to fail. Stick around,
No, I
because one
understand that y'all
defendant
might need some
allegedly
type of,
violated
I
18 times,
understand.
and yet nobody knew. Until now. Let's
Well,
dive
I
in.
don't know. All right, so this is the bond forfeiture docket, Nisi case number 24 DCCV 1018. And I guess these are both kind of similar issues with regard to the same bonding company, correct?
I think they're identical.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's,
On Mr. Celestine, and again, I think the issues are the same here, is that the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think, by the court to get a drug patch on one setting, given 24, 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court, not forfeited.
Now
Or
here's
left
where it
Mr.
gets
Romano
heavy.
his
Michael Collison
responsibility
agrees to plead no contest to larceny and meth use with the more serious possession charge dropped.
did I,
Sounds
well, I
like
mean,
a
if
win?
it's, if he.
Maybe. But look closer that no contest plea still carries the same sentencing weight as a guilty one. He avoids trial, but the consequences remain real. It's a legal chess move, and it hints at the DA's willingness to make deals when treatment and accountability might serve better than more jail time. Would you take that plea if you were in his shoes? Here's a key legal moment you might have missed. The judge says this bond should have been revoked, not
Did you not
forfeited.
know
So
about
what's
the
the
court
difference,
dates?
and why
I
does
mean,
it matter?
regardless of,
A
if
revoked
there's a
bond
bond
means the
violation,
court
a
is
lot of
officially
times what I'll
pulling the
do
bond due
is,
to
if it
non-compliance,
comes
like
to my
skipping a
attention
drug
through,
patch.
Ms.
A
Werner will
forfeited
get the
bond, on the
emails
other
from
hand, means
whoever
the
it is that
bonding
they're
company
supposed to
now
have a
has to pay up,
GPS or
often due to a missed court
drug
date.
patch, and
The bonding
then
company argues,
if I
hey,
get
this
some
wasn't our
type
violation, it
of
was between the court
referral
and the
back from
defendant.
them that says
And they
either
may
they're
have a
not
point.
wearing
If
it,
they
or they
weren't
didn't
told
get
about new
it, or they
conditions, can
tested
they really be held
positive.
responsible when the defendant doesn't
Sometimes
follow
if it's
through?
a positive, I'll at that point just raise the bond and do an at-large without proper bond. If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on.
Now here's
Did
where
y'all-
it
are you
gets
saying
heavy.
you didn't know
Michael
about that
Collison
date?
agrees to plead no contest to larceny and meth use with the more serious possession charge dropped. Sounds like a win? Maybe. But look closer, that no contest plea still carries the same sentencing weight as a guilty one. He avoids trial, but the consequences remain real. It's a legal chess move, and it hints at the DA's willingness to make deals when treatment and accountability might serve better than more jail time. Would you take that plea if you were in his shoes? This is where things get heated. The bonding company claims the court added conditions after the bond was signed, essentially setting them up for failure. Think about it. The defendant was ordered in court to get a drug patch within 24 hours, but the bondsman wasn't there, wasn't told, and wasn't legally required to enforce it. Now they're facing a financial hit because of a condition they didn't even know existed. That's like signing a lease and then getting fined for rules added after you moved in. This moment raises a real question about fairness and communication between the courts and third parties. Is it reasonable to expect bondsmen to attend every single court session, or is the system outdated and due for a serious update?
They should attend the hearings. It's not appropriate for the court to.
Well, let me stop you. I think that the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting, where we can address if and how those conditions can be relayed when we do them here in court to you guys. But the thing is that's every court does it differently. But the court date and the bond forfeiture, it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke.
Mhm.
We set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking some kind of relief, because this next, I mean.
Now here's where
Well,
it gets
I don't know
heavy.
that I knew someone
Michael
violated
Collison agrees
18
to plead
times.
no
I didn't say
contest
you
to
did.
larceny
No, I'm
and
just
meth
saying,
use
I don't
with
know
the
that
more
either of us
serious
knew that,
possession
because
charge
if someone's
dropped.
violating an
Sounds
ankle
like a
monitor
win?
18
Maybe.
times,
But look
typically
closer,
it's
that
going
no
to immediately
contest
be
plea
at
still
large without
carries the
proper
same
bond, not just
sentencing
let's
weight as a
reset a
guilty
hearing
one.
for a week
He avoids trial,
out,
but the
because I would be
consequences
concerned
remain
about
real.
that.
It's a
So
legal chess move, and it
sometimes we
hints
may
at
not
the
get
DA's
it
willingness to make
from the
deals when
company
treatment
until
and
they say, oh,
accountability
look,
might
there's been a
serve
whole
better
lot
than
of
more
these.
jail
And
time.
so we don't
Would you
know
take
that
that plea if
either.
you were
So
in
that's
his
obviously
shoes?
something we need to take
18.
up. I
That's
guess,
how many times one defendant allegedly violated their ankle monitor conditions, and somehow no one caught it in time to stop it. This isn't just a paperwork issue, this is a public safety issue. The judge is clearly disturbed, questioning why it took so long for anyone, the court, the bondsman, or the monitor company, to notice and act. Meanwhile, the bonding company says they have no legal grounds to arrest or even track their clients once those conditions go beyond the original bond. The whole thing highlights a massive gap in accountability. Who's watching the watchmen when these violations start piling up? Be honest, if someone violated conditions 18 times in your neighborhood, would you
well, no,
expect someone to step in
he's
sooner?
getting them. They're getting them when they're initially done.
Yeah, it's fixed now. That issue.
That's been, yeah, we've been working on that. But what he's not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what my thing is. We can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
So these violations have to come from the court as far as the issuing the warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do it at large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations.
Now here's where it gets heavy. Michael Collison agrees to plead no contest to larceny and meth use with the more serious possession charge dropped. Sounds like a win? Maybe. But look closer that no contest plea still carries the same sentencing weight as a guilty one. He avoids trial, but the consequences remain real. It's a legal chess move, and it hints at the DA's willingness to make deals when treatment and accountability might serve better than more jail time. Would you take that plea if you were in his shoes? Here's the core legal clash: the bond agreement, a contract, never included the conditions the court later imposed. So now the bondsman's hands are tied. They're legally limited to acting on the terms of their contract,
So were
not
these
whatever
my
new orders the
conditions
court
on
adds
both of
later.
these, or
The
were
court
these
wants them to
conditions
re-arrest,
that were,
track, and control,
because I think
but the
that is
contract doesn't
different.
give
If
them
these were
that power.
conditions that were
It's
placed
a
by the
tug of war
magistrate at
between
the jail,
contract
or
law
were these
and court
conditions that
authority.
were placed on them
The
here in
judge
court
even
by me?
suggests modifying future contracts to include any and all conditions, but until then, the system is broken and everyone's passing the blame. This is more than legal theory. It's real money, real risk, and real lives on the line. Would you want to be responsible for someone's actions if the rules kept changing after the fact?
Okay, so these weren't the jail issue. Okay, all right, then I'm going to grant the forfeitures in each case, and then we can discuss somehow, if you gotta get with all the courts though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily the issue's going to be getting everybody to do with the same. But we can talk about it at bail bond board. All right.
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon.
We'll do so.
And take judicial notice of the bond forfeiture case and the underlying criminal case in each of those.
We'll do that as well.
And enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that.
Okay, thank you.
Thank you, Your Honor.
All right, and hey, remind me, and we'll try to.
Now
figure
here's
something
where
out.
it gets heavy. Michael Collison agrees to plead no contest to larceny and meth
Well,
use
I don't
with
know
the more
that I knew
serious
someone
possession
violated
charge dropped.
18 times.
Sounds like a
because-
win?
No, I'm just
Maybe.
saying, I don't know that
But
either
look
of us
closer
knew that,
no
because if
contest
someone's
plea still
violating an
carries
ankle
the same
monitor
sentencing
18
weight as a
times,
guilty one.
typically it's
He
going to
avoids
immediately
trial, but
be
the
at large without
consequences
proper
remain
bond, not
real.
just let's reset
It's a
a
legal
hearing
chess
for
move,
a
and it
week
hints at the
out,
DA's
because I
willingness to
would be
make deals
concerned
when
about that.
treatment and
So
accountability might serve
sometimes
better
we
than
may
more
not
jail
get
time.
it
Would you
from
take
the
that plea
company
if you were
until
in
they
his
say, oh,
shoes?
look, there's been a whole
In
lot
the
of
end,
these.
the
And
judge rules
so
to
we
grant
don't
the
know that
forfeitures,
either. So that's
siding with the
obviously
court's
something we need
authority
to
over the
take up.
bonding company's
I guess,
frustration, but the ruling comes with a clear warning.
Yeah.
The communication gap between courts and bondsmen is a ticking time bomb. Even the judge admits that this issue isn't going away. Bond conditions are often added later, and without a unified system, people will keep falling through the cracks. Whether it's drug patches, GPS monitors, or new court dates, everyone involved, judges, bondsmen, and defendants, are stuck in a broken loop. So what does this case really show us? That even in the justice system, communication can be the difference between freedom and financial ruin. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts.
Make it a habit. 7 minutes of Tai Chi every
and you're still being argumentative, even towards me.
Welcome to Bench Report Court Cam.
Good morning.
Good morning.
All right, this is cause number 1830854, and sir, you're Juan Sanchez? And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure.
I kind of agree with I don't want to subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay, I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably
The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah.
there was something that the court was ordering her not to turn over.
I shouldn't even be talking about this, but Powerball
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBlanc, is there, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens, we chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean, that's,
Right, I mean,
that's great. Everybody
it's all
can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here, saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused. I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're gonna have to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good?
Yes, Your Honor.
All right, thank you, y'all.
Thank you.
Thanks for
That's it for today, everybody. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. So you all have a wonderful evening. Ciao, ciao, and ta-ta. I will see you guys again tomorrow.